All right, can you guys see my screen okay?
Yep. We
Perfect.
see the slideshow and we see your picture, but not you.
Right. I know I'm trying to stay off video for the time being. My bandwidth is a little sluggish. So, can you guys hear me okay, or is there a delay?
I can't tell if there's a delay, but the quality sounds good.
Okay.
Would you like me to turn my camera off as well?
Um, I think you can, yeah, you can do that, and then we'll or let's do the intros, and then we'll both turn our cameras off when we
All right.
introduce, yeah, introduce Claire. All right, I still see some folks joining, so that's good. Going to give folks a few minutes to jump from one meeting to the next. Welcome to everybody. All right, so I'm going to come on camera and I want to kick us off and apologize. Internet is a little sluggish on my end this afternoon, but I want to kick us off and welcome you all to our May business to business meeting here at Disability in North Carolina. For those that I have not had the pleasure of meeting, my name is Beth Butler Fatal, and I am Executive Director of Disability in North Carolina. Want to share with you just a little bit about who we are and what we do. We are a private nonprofit and we support employers across the state that are committed to creating cultures that are open to including people with disabilities. And we do that with a tremendous board of directors, all representing companies across North Carolina that are on this journey with us to create cultures again that are open and welcoming to individuals with disabilities, both in their workforce, in their supply chain, and in their marketplace. We are one of 18 affiliates across North Carolina, all roll up to Disability in North, or I'm sorry, Disability in, our national partner that connects us to over 550 companies and corporations across the country. And so we are excited to be with you today. Again, this is the team, Pat Kuehl, our operations director, and then Justin Francis is our communications specialist, a consultant with us. So we are a mighty team, but we get a lot done in the with the small team that we have. So grateful for that. This next slide shares just some of the companies, our current members and sponsors. What I love most about this is, again, the diversity across industries that are represented here. So if your logo is not up here, I want you to consider asking questions, reaching out. We've got some of our board members on today's call. We've got a lot of companies we work with that would be more than happy to share with you the benefits of their experience in partnership with us here at Disability in North Carolina. We were the 2020 Affiliate of the Year. That was exciting for us. We were recognized at the national conference that happened to be a virtual event in 2020, if you guys remember, but certainly proud to have been recognized. For those not familiar, our signature programs include customized consulting. We do a lot of training and development opportunities for our business members and companies that come to us. We also promote a business mentoring program as well, where we connect businesses with college students with disabilities that are looking for building that business to business network and being a part of that conversation before they graduate. So that's a big piece of what we do. Obviously, these business to business meetings are also a way that we build our community and connect businesses with others that are doing great work and bringing important topics to you as well. So thank you again for joining our business to business meeting today. We also host 3 different events annually. We have a Wellness at Work event that we just hosted last week. And if you weren't able to attend that, we have a link that we will provide on our website. Awesome conversation related to wellness at work. And this year's topic was PTSD, resiliency and recovery, and shared stories of 2 of our veterans that have walked their own journey around post-traumatic stress disorder and that journey of recovery. So check that out on our website coming soon. And then in July, we host an ADA celebration. This will be the 35th anniversary of the signing of the ADA. That event will be an in-person event this year, July 24th, and our site host will be Biogen. So more information coming out on that, but mark your calendars for July 24th. We will be hosting an in-person event at the RTP, the Regional Triangle Park area, right there outside of Raleigh. So check that out. And then finally, our fall conference, celebrating Disability Employment Awareness Month in October. October 9th is the date for that event. And we will be back at Train Technologies on their beautiful campus in Davidson, North Carolina for that event. As a reminder, as soon as we get registration open for these events, it is a first come, first serve basis for sure. That fall conference sold out last year. So please, don't wait. Go ahead and get your registration and your tickets for that event so you have an opportunity to join us in October. And then our Ability Jobs portal, again, more information on our website at di-nc.org. But as you consider membership or sponsorship within our organization, if you join at that silver level sponsorship or above, you will gain access to the Our Ability Jobs portal, which is designed to help companies post open positions to a population of very skilled and talented professionals with disabilities. So check that out. Again, a really great resource and tool that we offer our sponsorship, our silver level sponsors and above. And with that, I want to highlight this one slide here because this is kind of the why behind what we do. If you are new to this conversation or if you're considering why this work is important, I want to direct you to the advantage or the disability advantage, getting to equal. It's a research that was done by Accenture back in 2018 that basically answers that question for you. And it says basically when a company spends time in this space, around disability inclusion, disability engagement, their companies enjoy a 28% higher revenue, 2 times higher net income, and they perform 30% better on economic profit margins than those companies that are doing nothing in this space. So if you're looking for that ROI, it's out there. And we would love for you to join us on this journey as we just, again, increase awareness and education. And today's speaker, I'm super, super excited to share with you that we recognize the dialogue that's happening nationally around disability in this space. What we know is that the ADA is still alive and well. And that is why we are very, very committed to including topics and bringing topics to you related to, again, what we know. And that is that the Americans with Disabilities Act is still solid ground, and employers need to be aware of that. And we are here to help you navigate these questions and these challenges. So with that, I'm going to stop sharing my screen, and as an opportunity to ask Claire Healy to go ahead and share her slides. You are in for a treat. Claire is an associate with K&L Gates, and they are a law firm. She sits in the employment area, does a number of different types of employment law, and was thrilled to be able to join us to share a little bit on this very profound topic on accessibility for all, disability inclusion in the workplace in the face of hostility towards DEI initiatives. So again, Claire, I'm so excited to have you join us, and thank you for your willingness to partner with us. You sit in the Raleigh office, but I know K&L Gates has a office in Charlotte, and I think, is it in Morrisville as well?
Yes, we do. We have 3 North Carolina offices, Raleigh, Charlotte, and then technically the Morrisville office, but everyone refers to it as RTP. So have a critical mass of attorneys here in North Carolina.
Fantastic. Well, we are excited, and so that means you have absolutely no excuse as to not be at the RTP event in July. So I think you have that on your calendar.
Exactly.
So that's awesome.
I
Well,
do now.
Wonderful. Well, with that, I'm going to turn it over to you, Claire, because I know you've got a lot of information to share with us today.
Thanks so much, Beth, and thank you all for joining this conversation today. That's really what I hope that it will be. I have these slides prepared and you're going to hear from me, but I welcome questions. I welcome feedback, discussion from any of you on the call. And this is something that I really enjoy talking about and am passionate about. So hope that, we'll have a really good discussion here today. This is just a little bit about me. As Beth stated, I am in what is very gray and gloomy Raleigh, North Carolina right now. I primarily practice labor and employment defense side. I represent employers in a wide range of employment disputes, including discrimination and retaliation lawsuits. So I have a great deal of experience with ADA charges of discrimination as well as ADA lawsuits. And I'm, always working with the EEOC and the state administrative agencies on the charges. And then I also provide a fair amount of advice to employers as they are navigating difficult employment issues within the life cycle. So that can be anything from, you're evaluating an applicant who might have a disability, or you have an employee who has requested an accommodation and you're not sure if you're going to be able to grant that or not, or appropriately documenting all of the efforts that you have made to accommodate an employee and how it's still not working. I would say that the ADA is something that I touch on at least a daily basis. So always here and happy to answer your questions. So today we're going to focus on employers' legal obligations under the ADA, how to address employee and applicant ADA accommodation requests, an overview of the recent DEI executive orders and guidance from the federal government, and then facilitating an accessible work environment while refraining from engaging in illegal DEI as it's referred to in the DEI executive orders. So first, for an overview of the ADA, of which I know that most of you on the call are familiar with. But essentially, the ADA is the federal law that prohibits disability discrimination. And then for the purposes of this discussion, I'm going to focus on the ADA's prohibition of discrimination in the employment context. So the text of the ADA actually says that no covered entity shall discriminate against a qualified individual with a disability, and we're going to get into those terms in a little bit later, because of the disability in regard to job application procedures, hiring, advancement, discharge, compensation, training, or other terms, conditions, and privileges of employment. So as you can see, as I previously mentioned, it really touches every part of the employment life cycle, from recruiting and onboarding to termination. You have to ensure that all decisions are made in a non-discriminatory way. So when we are looking at an issue under the ADA, there's going to be a couple of key inquiries. First, what is a disability under the ADA? Are we actually dealing with an employee or applicant that has what would be considered a disability under the law? Second, who is a qualified individual? We'll talk through this a little bit more, but the ADA doesn't require that you excuse certain requirements of your positions or, hire someone who's completely not qualified for a job. Perhaps you have a position that requires a master's degree. The ADA doesn't require you to hire someone whose highest level of education is a bachelor's degree just because that person has a disability. So that's what we get to when we're talking about a qualified individual. And then the third inquiry would be, what does the ADA's prohibition on discrimination actually require of employers? So what is a disability? So disability is defined by the law as a mental or physical impairment that substantially limits the individual in at least one of the major activities of life. So impairment is going to be a very broad definition. And as you can see from the plain text, it can be mental or physical. So this is something that we deal with on a regular basis, which is that some disabilities are obvious. You can observe them from interacting with the individual, versus some are non-obvious. And perhaps that could be a mental impairment, that could be a physical impairment that you can't easily observe. Nonetheless, it should still be treated the same way as if you can observe an individual who needs to use a wheelchair, for example, in order to move throughout. Substantially limiting is another aspect that you need to look at to understand how limited is the individual by the impairment. And then talking about their major activities of life. So when we're thinking about whether or not the impairment is impacting their major activities of life, it's important to not consider the effect of a medication or an assistive device that could correct or lessen that impairment. So what are major life activities? So normal activities of living can include caring for oneself, seeing or hearing, eating or breathing, sleeping, walking, standing, lifting, bending, learning, reading, concentrating, thinking, communicating, working. So these are all activities in which that if an individual identifies that they have an impairment that prohibits them from carrying out these functions, that they perhaps would need an accommodation. So you'll see that there are certain activities on here that are not listed as a normal activity of living, just as an accepted matter of course. And occasionally in ADA litigation, that can become an issue of fact of whether or not the individual's impairment actually impacts an activity of living. Ideally, that's not going to be the reason that we deny an accommodation. As an employer and as counsel who advises employers, I would typically advise that you refrain from making decisions related to the level of severity of an employee's impairment and how it impacts their living abilities. So, but these are ones that are very well accepted as these are major life activities. So I've touched on this earlier, but to be a qualified individual, the person must have the requisite skill, experience, education, and other job-related requirements of the position. So as I mentioned, there's no reason or need for you as the employer to excuse requirements of the position simply because you have an applicant with a disability that has applied. It's actually in your best interest and in that individual's best interest that you select the best candidate for the position, regardless of any protected characteristics, which we're going to talk about a little bit later. Secondly, to be a qualified individual, the person must be able to perform the essential functions of the position with or without accommodations. So this, as a practitioner who works with the ADA, I feel like I could say this sentence over and over and over in my sleep. Essential functions of the position with or without reasonable accommodations. That is the money. That is what we're looking at. Can you perform the job without an accommodation, or is there some accommodation that we as the employer can easily provide to you that will enable you to perform the job? So what are the essential functions? The essential functions are the basic duties of a job that the person must be able to perform to hold a particular position. So managers should work closely with human resources in identifying and communicating the actual essential job functions of a position. This is something that we commonly see as an issue, which is you have a written job description that doesn't accurately reflect what the requirements of the position actually are. So then when you go to evaluate an accommodation request, you're looking at the written job description, but that's not consistent with what you actually need the employee to perform, which is then difficult to communicate with the employee's medical provider about how can they perform the essential functions of their position. And it also it's not good evidence for you, the employer, if the employee were to file a charge of discrimination or a lawsuit that this actually is an essential function you need them to perform if you fail to include it in your offer letter. So common pitfalls that I see come up are things like travel. Sometimes it'll be a position and travel is not, say, required all the time, but it's required sporadically. Maybe you need the employee to travel, once a quarter, but you fail to put that in your job description, and then your employee comes to you with a disability that they say, makes them not able to travel. And you think to yourself, well, this position has to travel once a quarter. We have this big conference every quarter, and we need this person to be there. If you haven't written that in your job description, you're going to be in a bit of a difficult situation. Another common pitfall that we see, especially now, after the COVID-19 pandemic, since there's been a transition to so many workers in a more hybrid or remote work environment, is that employers will fail to make a distinction of, yes, your position is hybrid, or yes, your position is primarily remote, but there are going to be certain days or certain meetings or events that are going to require you to be in attendance in person. And if things like that are not communicated in an offer letter or a job description, again, then that can, pose potential issues when you're evaluating essential functions. Other key evidence where essential functions may be found, the job posting. So if you have posted the position and it details, the responsibilities of the role, the offer letter, employment agreement, job description, and then also in employment policies. So oftentimes we have to refer to employment policies when there are things like employee conduct or employee attendance that are implicated by an employee's requested accommodation or disability. So for example, if an employee's requested accommodation is that they need to be late to work or, have a delayed start for an indefinite amount of time, then we might say, that's not a reasonable accommodation because, as you can see in our attendance policy, the expectation is that all of our employees, for whatever, manufacturing needs or whatever business needs, need to be on the production floor at 8 a.m. first shift, and we can't accommodate someone in that position starting every day at 10. So evaluating accommodations under the ADA. So what is a reasonable accommodation? A reasonable accommodation is a modification or an adjustment that's made to a job, the work environment, or the way that things are usually done to enable an individual with a disability to perform the essential job functions or enjoy equal employment opportunities. And it's reasonable if it does not impose an undue hardship on the employer. So that's part of the analysis that we're looking at each time an employee requests a reasonable accommodation. The first would be, is the accommodation that they've requested going to actually enable them to perform the essential functions of their position? If not, it's not reasonable. If it would, but it's going to pose an undue hardship on the company, then it also might not be reasonable, in which case the employer would have a basis to deny the requested accommodation. When we're thinking about things like undue hardship, you're wanting to evaluate the accommodation in terms of cost and efficiency. And this can mean cost both in terms of actual dollars and cents, and as well as cost of, I call them time, talent, and energy. So for example, if you have an employee who requests an accommodation and it would require a completely different scheduling assignment, and it would require an individual within your HR function to have to essentially, look at a department, reassign employees, make a new schedule. Perhaps you might determine as the employer, if you only have one HR employee, that that's an undue hardship. You cannot allow, or you don't have the capacity to allow that employee to focus solely on that for that period of time because you have other HR functions that you need that employee to be doing. In any situation where you're dealing with the ADA and a reasonable accommodation request, it's always going to be very fact intensive, and you're always going to want to evaluate each request on a case by case basis. So that's going to be both the request itself and then the whether or not it's an undue hardship. So something could be an undue hardship in one circumstance and then later down the line not be an undue hardship. And that's where documentation is really important for documenting the process by which you looked at how would we accomplish this? What would it take for us to accomplish this? Why is it difficult now, but it wasn't difficult then? And really creating a very holistic record of why you made that decision and how you can support it. So here are some do's and don'ts for evaluating reasonable accommodations. Do review the financial and administrative burdens to the company with respect to the accommodation that's requested. Do consider the impact of accommodations on other employees. So that's another factor to think about when you're thinking about undue hardship. If you grant the accommodation to this one employee, is that going to make all other employees feel uncomfortable? Or is that going to make all other employees have to do more work? Things like that in some ways could then impact the experience of other employees negatively. Do request additional information to evaluate the requested accommodation. So this gets back to what I initially said about, as the employer, you don't want to be the one making the decision about the severity of the individual employee's impairment or about what types of accommodations you think would accommodate their disability. So that's why it's really important to have an open dialogue with the employee, with their healthcare provider, and come up with an accommodation that is supported by the healthcare provider, where the healthcare provider has actually reviewed the job description and says, I believe that with this accommodation, this employee could perform these essential functions that you have articulated. In the same vein, don't eliminate or alter essential functions of the position. This is something that we see happen a lot. You have an employee, they are, usually what happens is that they say, for a short period of time, I'm not going to be able to do this. And you're wanting to do the right thing, you're wanting to work with them. And so, you say, okay, we're gonna, temporarily, you don't need to do this one part of your job role. And then, you revisit it and it turns in 3 months and they haven't been doing that part of their role, but now that's kind of been too long and you need them to either do it or you need someone else to do it. And so, that can be a really tricky situation and a slippery slope. So you really want to make sure that the accommodation is something that enables them to perform the essential function. And if it's not, a leave of absence in some instances can be a reasonable accommodation until the employee can propose an accommodation that would enable them to perform the essential functions. Don't reallocate essential job duties to other employees. That's a really good way to tank your employee morale. And don't reduce productivity standards. So don't take a disabled employee and suddenly say, well, we don't think that you can do this job anymore. So while your previous quota was 500 widgets, now your quota is 250 widgets. You don't want to change their terms and conditions of employment just because they requested a reasonable accommodation. So what are your obligations with respect to accommodations? So first, the disabled employee has the obligation to put the employer on notice that he or she needs an accommodation and to suggest a reasonable accommodation. An accommodation that does not allow the employee to perform the essential functions of the position is not reasonable. An employer also does not have to accept a proposed accommodation from the employee if an alternative accommodation exists and it will accomplish the necessary result. So an example that I like to use here, and it's kind of extreme, but I think it does a good job of displaying this. So you have an individual who uses a wheelchair for mobility issues, and they say, I can perform every function of this job. The only thing is, my team meets on the second floor and there is no elevator. So I need you to install an elevator into the building. You, as the employer, could say, thank you for requesting this accommodation. We value you as a member of the team. We think that you can perform the essential functions of your job as long as you can, get into our office and be with your team. But unfortunately, because of cost and time constraints, it's not feasible for us to install an elevator in our facilities. So what we're going to do is move your team to the first floor. So each day when you come in, you can use the ramp to come in and go straight to your office. There are no stairs. And the rest of your team will be there. So that's essentially achieves the same result. Employee gets to work with their team, experience the camaraderie, experience the collaboration. But instead of it being the costly elevator installation, it's just moving a few people around and moving some desks. As far as examples of other reasonable accommodations, so this is just what I was describing, modifying environments. So that is making facilities that are easier to access, or acquiring or modifying equipment for employees. Reassignment can oftentimes be a reasonable accommodation. If you want to reassign an employee to a new position, there's no duty under the law to promote or create a new position. But if you have an open position that the employee is qualified for, then reassignment could be a reasonable accommodation. Modifying work schedules. So I know I previously used an example where modification of a work schedule would not be a reasonable accommodation. I think the example I used was, shift work and we need everyone on the line, the production line starting at 8. Okay, if I take that example and apply that to a different set of facts, and we have an office worker who says, I suffer from migraines. They're really bad when I wake up in the morning. But, as soon as I wake up, take my medication, drink a glass of water, within 2 to 3 hours, I feel better. I think that I could get my workday started every day at 10, and I could work from 10 a.m. to 7 p.m. Would that be okay? In that case, assuming that that's would work for the type of business that the employer is in, I would strongly recommend that employer consider granting that accommodation. Adjusting policies, examinations, or training procedures. So this can be things like you have an employee who suffers from dyslexia or ADHD who needs additional time on examinations or training procedures. Again, those are really easy accommodations to make for employees to increase your inclusivity of disabled individuals within your workplace. And then, as I previously mentioned, in some situations, leave can be a reasonable accommodation under the ADA. So often this comes up in two contexts. One will be, we'll say it comes up in three contexts. So the first would be if you are an employer who is not a covered employer under the Family and Medical Leave Act. So you don't have, you're either not a covered employer or the employee is not eligible for FMLA. Then if they need a leave of absence to deal with any type of, health related issue. So if they need to have a surgery or they have surgery and recovery time, then you should consider providing a leave of absence as a reasonable accommodation under the ADA. This also often comes up after an employee who is eligible for FMLA has exhausted all available leave. So sometimes what we see is that they've exhausted all available FMLA leave, and lots of times we get the question from the employer of, okay, what now? They've had 12 weeks out. They are saying that they don't know when they can come back. What do we do now? And we would always recommend that at that point that the employer engage in the interactive process with the employee to understand, do you need additional leave? How much more leave do you need? Is the idea that this additional leave is going to help you in recovery and that you will eventually be able to return to work? If that's the case, then the employer should certainly consider providing, a set duration of additional leave.
8.
Sorry, did we have a question? Okay, I don't think so. So I want to talk a little bit more now about undue hardship and what is a court of law going to look at when talking about undue hardship. So often courts are going to consider the size of the employer, the financial resources of the employer, and the job that's being performed by the employee. So in the previous example I gave, where the employee was requesting, the reassignment and the restructuring of an entire department, and then the employer only has one HR employee. Okay, so in that circumstance, the court might find an undue hardship. Take that example and pivot it to a, Fortune 500 company that has 20 HR employees, then a court might say, no, it would have been reasonable for one HR employee to spend a couple of days figuring out how this could have worked so that the employee could continue performing the essential functions of the position, which I think again just goes to show how fact intensive it is, which can be really the challenge in litigating these issues. And circling back on the issue of leaves, I want to be clear that with respect to an undue hardship, employers are not required to provide an indefinite leave of absence or tolerate excessive absences. So if you have communicated with the employee, you have provided leave even beyond what the employee is entitled to under FMLA, or if they are not eligible for FMLA, if there is not a anticipated return to work date or reassurances from a healthcare provider that, hey, you know, with just one more week of leave, I believe that this employee can recover and return to work, there's no obligation to just keep providing more leave. So what is the interactive process? So the interactive process is the ongoing dialogue between the employer and the employee with it, consultation with the employee's healthcare provider regarding the accommodation requested and whether or not it is reasonable. So when you are on notice that an employee has requested an accommodation, you do want to engage in the interactive process as quickly as possible. So you want to identify both the limitations created by the disability and potential accommodations. This is really the area where having that healthcare provider statement is really important because, again, you don't want your HR professionals being the ones that are, you know, identifying or assuming that they understand the limitations posed by an employee's disability. And document the process. So to the extent that you can, you know, document any calls with the employee via notes after the fact, keep any communications and emails, letters between the employer and the healthcare provider, subject to a medical authorization by the employee. Really want to make sure that any communication related to the accommodation process is documented. Do not delay. Unreasonable time in engaging in the interactive process or responding to an accommodation request can be considered a violation of the ADA. So you want to make sure that you're moving promptly. Don't require the employee to take leave as the only option. If the employee is ready, willing, and able to work and they are proposing various accommodations, you should work through those, and it should really only be that after you've determined that none of those accommodations can be provided, that you pursue leave as the accommodation. Now, in some cases, leave is going to be the first accommodation requested. So, for example, if they need to have surgery, need time to recover. But this is in the example where they're requesting an alternative accommodation. And then don't take the disability into account when making the employment decision, or don't take the disability into account or the fact that the employee has requested an accommodation, because treating an employee differently for requesting an accommodation under the ADA would be considered unlawful retaliation under the ADA. So the interactive process is going to be triggered as soon as you know that the employee may need a reasonable accommodation or the employee makes a request for an accommodation. Oftentimes employers will have, especially large employers, will have policies that say, you know, this is how you request an accommodation. And the reason that they do that is so that each employee is following the same process. The requested accommodation is going through the appropriate channels. You have HR involved, so you don't have managers who might not be familiar with the ADA evaluating these requests. But one common pitfall that I see often is that companies can get really hung up in their processes and sort of fail to interact with the employee, and they just want to keep saying, well, you need to follow the process, you need to follow the process. And while there is some ability to, make the employee follow appropriate channels, you don't want to have that be your sole justification for a reason why you delayed on granting an accommodation or denied an accommodation. Like, I don't think that that's going to be a compelling reason to accord. And then, as we've discussed, you cannot take an adverse action against an employee because of a disability or retaliate against an individual for engaging in conduct protected by the ADA. So that would be, if the employee says, I think I've been discriminated against by my disability, or I requested an accommodation and my supervisor started treating me differently. Importantly, though, an employer may take an adverse action against an employee because of an employee's unacceptable behavior in the workplace, even if that behavior was a result of the employee's disabilities. So an example of this is you have an employee who suffers from a mood disorder, and that mood disorder is episodic, and it causes the employee to, suffer a violent outburst while at work, and he threatens another employee, violates your conduct policy. Obviously, you can discipline that employee for those things, even though the conduct was a result of that underlying disability. So shifting gears a little bit now, I want to talk about the Trump administration's recent focus on the concept of illegal DEI since President Trump resumed office in January. So President
Claire, we do have a question.
Oh, of course.
Yeah, I want to make sure it gets addressed. In what phase of the employment process is it most ideal to request the accommodation, but before an offer is made or after an offer is made? This is someone who has not started employment.
Yeah. It's really dependent on what you feel most comfortable with. Obviously, the employer cannot ask about accommodations or your disabilities before an offer is made. They can post offer, but it would be perfectly acceptable for you to go ahead and notify them pre-offer that you have a disability, or that you feel like you can perform the essential functions of the position that you've applied for, except for, you've identified this one in the job posting that from the beginning that you would need a reasonable accommodation for. So, a good example for that is if the position says, you'd be required to lift 5 pounds, and you say, I hurt my shoulder a couple years ago. I know I can't lift 5 pounds. Or I would need to wear, a back brace to lift 5 pounds. Is that a problem? So you could certainly do that pre-offer.
Thank you.
Yeah, of course. So turning to the executive orders. So the first was the executive order, which was directed at all federal agency and department heads, titled Ending Radical and Wasteful Government DEI Programs and Preferences. So this order directed the agency and department heads to terminate all DEI, DEIA, and environmental justice offices and positions. So, for example, any chief diversity officer positions. Required them to terminate any equity action plans, equity actions, initiatives, programs, equity-related grants or contracts, and DEI performance requirements for employees, contractors, and grantees. So the next executive order is ending illegal discrimination and restoring merit-based opportunity. This directed all executive departments and agencies to terminate discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulation, enforcement actions, consent orders, and requirements, and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. It notably revoked Executive Order 11246, which required federal contractors to take affirmative action to ensure equal employment opportunity for women and minorities. And the order specifically identified the protected characteristics of race, color, sex, sexual preference, religion, or national origin with respect to discriminatory and illegal preferences. The United States Attorney General issued a memorandum to the Department of Justice employees, providing the Department of Justice's Civil Rights Division with the instruction to investigate, eliminate, and penalize illegal DEI and DEIA preferences, mandates, policies, programs, and activities in the private sector and in education institutions that receive federal funds. This memorandum specifically references programs and initiatives that discriminate on the basis of race and sex, and clarified that the law does not prohibit educational, cultural, or historical observances that celebrate diversity, recognize historical contributions, or promote awareness without engaging in exclusion or discrimination. The Equal Employment Opportunity Commission published guidance entitled What to Do If You Experience Discrimination Related to DEI at Work in March of this year. Notably, the guidance notes that individuals may have colorable hostile work environment claims related to DEI training if the training becomes so severe that a reasonable person would consider it intimidating, hostile, or abusive, and that individuals may engage in legally protected conduct pursuant to Title VII if they are objecting to or opposing discrimination related to DEI or engaging in reasonable opposition to DEI training. So as you can see, this is a high priority of the federal government to focus on what they are calling illegal preferences, illegal DEI, illegal discrimination under the guise of diversity, equity, and inclusion. So where does that bring us with respect to disability? So there are two major protected characteristics under federal anti-discrimination law that are notably absent from the DEI executive orders and the enforcement guidance from the federal government. And that would be disability under the ADA and veteran status under USERRA, the Uniform Services Employment and Reemployment Rights Act. I don't think that it's difficult to conceptualize of why that's the case. I think that it's the Trump administration doesn't want to be seen as in any way anti-disabled individuals or anti-veterans. The issue is that the executive orders will, on occasion, refer to DEIA initiatives, programs, practices, with the A standing for accessibility, which would relate directly to disability. And they seem to group all such initiatives together. So it leaves us with this sort of sticky situation to walk through of what should we be doing then with any DEI programs that are focused on promoting inclusivity and accessibility for individuals with disabilities. Part of the reason that the DEI executive orders don't address disability is that certain programs that promote disability inclusion and accessibility are required under federal law, such as the Rehabilitation Act. So Section 501 of the Rehabilitation Act forbids discrimination by federal agencies against people with disabilities and requires federal agencies to implement affirmative action for people with disabilities. These requirements come from statutes and regulations, which means that they can only be changed by acts of Congress and the formal rulemaking process. So these requirements can't easily be undone by executive orders, which is part of the reason why the executive orders sort of took a more measured approach with respect to disability. And so then for the final section of my presentation, I want to talk a little bit about how accessibility in your workplace does not have to equal illegal DEI, because as we just previously discussed, obviously there were a lot of scary directives in the executive orders, and there were a lot of missives from the federal government saying, you know, this is who we're looking at. This is what we're going to be investigating. This is what we're going to be focusing on. And it's all related to illegal DEI or DEI preferences. And so, you know, what most organizations are struggling with right now is how do we encourage inclusivity and accessibility within our workplaces while also not drawing the attention and the ire of the Trump administration? So how do these orders impact your legal obligations? So it's just as Beth said at the top of the program, the ADA remains in full force and effect. So everything that we've discussed thus far in the programming remains the same. Employers must continue to comply with the requirements of the ADA, which include providing reasonable accommodations, engaging in the interactive process, and prohibiting disability discrimination. And one of the key takeaways that I hope that you get from today is that right now, the anti-DEI efforts have not yet been targeted at organizations that are making, you know, are promoting accessibility and inclusivity for individuals with disabilities. But given the broad and sweeping language of some of the orders, I don't think that we can just sort of assume that that's going to be the status quo from here on out. So you can and should provide a workplace that is accessible to individuals with disabilities without engaging in illegal DEI. So the two major considerations in determining if your programs, practices, or initiatives could be considered illegal DEI is whether or not an employee or applicant's protected characteristic is being considered in any way as part of the employment decision, and whether the employer applicant is being treated differently, either positively or negatively, because of their protected characteristic. So those are the two things that you really want to keep in the back of your mind when considering if any of your initiatives should be disbanded or rebranded in any way, you know, in light of the government's focus on illegal DEI. So the way that you do that is you promote access and inclusion while avoiding preferences. So you want to ensure that all employment decisions are merit-based, regardless of an employee or applicant's protected characteristics. So that means disregarding things like plus factors, preferences, quotas, all things which, to be clear, were already illegal before the executive orders. These were already things that, you know, if you had come and asked for our advice, you know, we would have said you should not be doing this in an employment decision. If you have two equal candidates, you shouldn't be hiring the candidate who's disabled just because they're disabled. There needs to be some non-discriminatory or some basis that's not based on a protected characteristic for why you're giving that employee the offer. You do need to end any programs that are limited only to a certain protected class. So that can be internships, training programs, mentorship opportunities. If you have any of those, particularly those limited only to a certain sex or race, you certainly want to go ahead and suspend those. Evaluate any employee affinity groups and ensure open access to all individuals. So this is one that could be a little bit tricky, and you want to be thoughtful about how you message this with employees. So think about how, if you have an employee affinity group that's primarily been for employees with disabilities. For example, I work with a client who they have an employee affinity group for their neurodivergent employees. If all of a sudden you say, you know, we can't have a neurodivergent only affinity group, it has to be open to all employees. So even employees who don't identify as neurodivergent need to be able to join. You have to think about how that's going to impact those employees who are neurodivergent, and you know, now they are participating in a group where sort of that what was their safe space isn't there anymore. So you certainly want to be thoughtful about messaging around that. don't overcorrect. So if there are changes that your organization needs to make to its DEI programs and initiatives because of your executive orders, first off, you're not alone. There are plenty of organizations across the country that have had to make changes and, or just have chosen to do so from a risk assessment perspective. But you should do so thoughtfully without just saying, well, we are just going to rid our organization of all inclusivity efforts. That would be to the detriment of your workplace's culture and ultimately could have a negative impact and go in the other direction and have, increased claims of discrimination, retaliation, harassment. You need to, of course, continue to comply with all requirements under the law of providing training with respect to those topics, have policies that address those topics, make sure employees know how to report harassment, discrimination. These topics and concepts don't need to become taboo just because of the executive orders. If there are certain positions within your organization that you have to eliminate, such as a chief diversity officer, ensure that the position's responsibilities are transitioned to another executive who can carry out the necessary obligations. So, for example, if your chief diversity officer was responsible for, scheduling the annual sexual harassment training for all employees, just because you don't have a chief diversity officer anymore doesn't mean your obligation to provide that harassment training has gone away. So you want to certainly make sure that someone else has sort of picked up that baton and is able to, carry that out for your employees. So I think that is the end of my substantive slides. And I know that I spoke for a long time. I think we just got a minute here, but if anyone has any questions, I'm happy to stay on and answer them.
Well, I'm completely impressed. This is Pat speaking.
Yeah, thanks, Claire. That was a lot. It was a lot. But honestly, it all sounds somewhat familiar. So for those of us that have been around for a while, it's kind of reminding us what we know, right? Even in the face of some of the kind of swirling information that's been flying around. I love what you said in terms of a reminder, and I think you and I said this in the early stages of our conversation when we first met, and that is, I don't know that we have never been asked, especially in the area of ADA, to hire an individual with a disability who's not qualified to perform the essential functions of the job, with or without that accommodation. And so I think it's a great reminder and kind of level setting for us, is that's not what we've ever been required to do. And as I've said to many of our employers, if that has happened, that's on you, right? I mean, we don't hire people that aren't qualified to perform the jobs that we have for them to perform. So that's important for us to recognize. So I want to thank you for that. Are there other questions? I'm looking in the chat as well. I want to give folks time to.
Yeah, we have a compliment. Yeah, Beth, Brian Wright is saying great content. Thank you. Thanks, Brian.
Anytime, Pat.
Great. And there's our friend.
We certainly
Betty.
hope this has been beneficial to listeners.
Yeah, definitely. And Betty Morrow Taylor, it's great to see your comment. Thank you for joining us. Betty has been a longtime friend of disability in North Carolina with NC Commerce in Raleigh. So again, appreciate it. This content is important and is not going away anytime soon. I think we're going to continue to have these conversations throughout 2025 and beyond. So again, thank you guys for your attendance today.
Thank you, Beth, and for the work that you all are doing to make sure we're staying informed. Very helpful.
Great.
Keep up the great work.
Thank you. And Pat, can you remind us, so our next business to business meeting is coming up, is it June 12th? Did I see? I think it is. I didn't
It
mean to
is
put you on
June 11th.
June 11th. All right, perfect.
No, it's fine. June 11th. I've just got a barking dog, so if you're hearing that, that's what's going on.
No, I'm good. We don't hear it. All
Yep.
right.
June
Well, Claire,
11th, and also want to remind people that July, we have our ADA celebration. It's going to be in Raleigh.
that's right. So yeah, registration
And our
will open.
sponsor is Biogen.
Well, our site sponsor is Biogen. Yes. So excited about that. So more to come. Just watch those e-blasts and newsletters for registration to open. But Claire, again, I want to thank you so much for your partnership. We're excited to know that K&L Gates is here, and look forward to growing our partnership with you in the coming months and in 2025. So thank you.
Absolutely. Thanks so much for having me.
All right. You guys enjoy the rest of your day, and we will see you next month. Thank you.